Hey guys, welcome to my legal classes. This is Ganesh Pujari, and what are we going to discuss today? Judgment. Judgment we need to understand not only for the purpose of exam. Being a law student or being a lawyer or being an advocate or being a judge or being that any person who is practicing anything in the area of legal, we need to know much better than the common man. Now, where are we getting this particular topic? Chapter 27 of CrPC, which has as many as 13 sections on judgment. Starting from section 353 to 365, 13 sections are discussing about judgment, and in my today's class, I am going to discuss the first two sections which are very important, that is section 353 and 354. I have meaning, I have case laws, and I have all the details of these two sections in very simple English. Why to waste time? Let's get into the first slide. Okay, let's start the discussion with meaning and case law. Yes, in the first slide itself, we got a case law. Now, first thing first, let us try understand the dictionary meaning of judgment. I have two meanings here. The first being, judgment is a decision of a court regarding the rights and liabilities of parties in a legal action or proceeding. I am not connected to this one very much, but the next one is very interesting, which says judgments also generally provide the court's explanation of why it has chosen to make a particular court order. I think this is quite reasonable definition. Now in CrPC there is no definition for judgment, but remember there is an independent chapter which is chapter 27 which we have started discussing now. But if you want to refer CPC for a definition on judgment, yes, there is a definition available under section 29. Guys, it is not CrPC, it is section 29 of CPC, that is Civil Procedure Code, which says judgment as the statement given by the judge of the grounds of a decree or order. Now that is the definition given under section 29 of CPC. One case law, that is Damu Senapati and 7 others versus Sridhar Rajwar, it was mentioned that judgment means the expression of the opinion of the judge or magistrate arrived at after due consideration of the evidence and of the arguments. So this is one beautiful sentence which is there in this particular case law, and I hope that is a beautiful definition as far as judgment is concerned. Now let us discuss one by one section these two important sections, that is section 353 and 354. First, section 353, which discusses about judgment with 8 beautiful subclauses. I have all the 8 subclauses in a very simple English, and I am going to explain them one by one. The first subclause discusses about who will give the judgment, where will be the judgment given, when will be the judgment given, and how exactly is judgment given. First thing, who will give the judgment? The presiding officer of the criminal court of original jurisdiction will give the judgment. Then where will be the judgment given? It will be pronounced in the open court. Remember to mention the word pronounced, that is very important. Where will it be pronounced? It will be pronounced in the open court. And third one, when will be the judgment given? There are two options. One, maybe immediately after the termination of the trial. That is an easy option. The trial is over, on the same day immediately the judgment can be pronounced. Or the other option is the presiding officer may give an independent date to the parties or their pleaders, and he can announce the judgment on that day also. That is one another opportunity. And how are the judgment given? There are 3 subclauses here. One, by delivering the whole of the judgment, or by reading out the whole of the judgment, or maybe by reading out the operative part of the judgment. These are the 3 opportunities that the presiding officer got. If the judgment is given as per 1C, that is reading out the operative part, in that case the presiding officer needs to explain the substances of the judgment in a language which is understood by the accused or his pleader. That is very important. Then comes subclause 2, 3, 4, which are going along with subclause 1. Now subclause 2 says if the whole judgment delivered as per 1A, then the same needs to be taken down in shorthand, every page to be signed by the presiding officer, and date of delivery of the judgment in open court should also be mentioned in that particular pages. Now, subclause 3 says if the whole or the operative part of the judgment was read out as per 1B and C, then the same needs to be signed and dated by the presiding officer in the open court, and if it is not written with his own hand, every page of the judgment shall be signed by him. That is very important. Then comes subclause 4, which says if only operation part was read out, in that case the whole judgment or a copy of the judgment should be immediately provided to the parties or their pleaders at free of cost. Now, are they really given at the free of cost? That is a question, but that is what subclause 4 of section 353 says. Subclause 5 and 6 are very interesting and very important, which are discussing about the requirement of presence of the accused in the court during the pronouncement of judgment. Subclause 5 says if the accused is in the custody, he need to be brought up to the court to hear the judgment. And subclause 6 deals with the accused who are not in the custody. In that case, what happens? He shall be required by the court to attend the judgment. But however, there are 3 exceptions available here. The first being if his personal attendance during the trial has been dispensed, or if the sentence is only fine, or if the accused is acquitted. In those cases, the accused need not to be present during the judgment. Now, what happens if there is more than one accused? If more than one accused are there and if some from there are missing, court may go ahead with the judgment to avoid the delay in judgment. That is what mentioned in subclause 6. What happens once the judgment is announced? The party which has lost always try to give a reason that this is not a valid judgment. They will try find some reasons, and subclause 7 discusses about few reasons which can't be a reason to say that the judgment is invalid. Like if there is an absence of any party, or if there is absence of any pleader, or if there is an omission to serve the notice, or if there is any defect in the notice that has been served. Nothing can be a reason to say that the judgment is invalid. Now, just because the date or place something is changed, if there is some defect in the served notice, or if there is a notice not at all served, or if there is an absence of party, or if there is an absence of pleader, nothing can become a reason to say that the judgment is invalid. That is very important. The last subclause, nothing in this section shall be constructed to limit in any way the extent of the provisions of section 465. What is section 465? Finding or sentence when reversible by reason of error, omission or irregularity. That remains same. 465 remains same. Nothing will happen with section 353 on section 465. Then comes section 354, which discusses about language and contents of judgment. Now this is a beautiful section and there are 6 subclauses. I am going to discuss them one by one. Now the first subclause discusses about 4 important points. The first one shall be written in the language of the court. The judgment should be written in the language of the court, and in the case law, that is Nageshwar Sri Krishna Gube versus State of Maharashtra, it was mentioned that the language should not be too difficult, but I don't know how far it is followed. The language that are being used by judge is difficult to understand. The people who are practicing law itself forget the common man. Now the second point discusses about the judgment should mention point or points for determination along with the decision and the reasons for such decision. Every point or points to be mentioned that how such judgment is arrived. That is very important. Now, while writing the judgment, there are 2 opportunities. One, either the accused will get convicted or he will be acquitted. What if he is convicted? If he is convicted, offense as per IPC or other law which section should be mentioned, and there should be punishment also very clearly mentioned. And if he is acquitted, then there should be clear statement on from which offense the accused is acquitted and direct that he be set at liberty. All these points needs to be mentioned as required in the judgment. Sometimes what happens while writing the judgment, there will be confusion. Like if there is any confusion to choose between 2 of the sections of IPC, or if there is a confusion to choose one part of the same section from the IPC, Now there is one subclause which supports the judge or the presiding officer, which reads, when the conviction is under the Indian Penal Code and if it is doubtful under which of two sections or under which of two parts of the same section of that code the offense falls, the court shall distinctly express the same. That means it needs to clearly write that there is a confusion available that needs to be mentioned and then pass judgment in the alternative. Whichever suits, whatever punishment suits, that they can decide. But that need to be mentioned that there is a confusion to choose a section or to choose a part of the section. This is only with the IPC. That part you need to remember. What if there is a death punishment available for particular offense and there is an alternative to give imprisonment for life or certain number of years of punishment? Now what is easy to choose for a judge? Guys, remember, it is easy for a judge to choose the alternative punishment like imprisonment for life or imprisonment for a term of years. He need not to give any reason for that. But if he is giving death punishment, he need to give clear details. That is what discussed under subclause 3, which reads, when the conviction is for an offense punishable with death, or in the alternative, that means there are alternative available. What? With imprisonment for life or imprisonment for a term of years. The judgment shall state the reasons for the sentence awarded, and in the case of sentence of death, the special reasons for such sentence. Now, if there are alternatives available, of course, imprisonment for life or imprisonment for a term of years is given instead of death. They have to give the reason. But if they are deciding to go with death sentence, then they need to mention special reasons, which is very, very difficult. They have to very clearly say, they have to voice out that why are they going with death punishment? Why are there are no alternatives for that particular accused? That is very, very important as per section number 354 subclause 3. Subclause 4 is very easy. If somebody is got convicted for an offense which is punishable with more than 1 year term of imprisonment, and if the presiding officer is deciding to give imprisonment for less than 3 months, in that case he need to very clearly mention in record for all the reasons that he is avoiding such sentence. That is very, very important because the imprisonment is for more than the term of 1 year, but he is giving only 3 months or less. In that case, he has to mention why he is giving that consideration. That is very, very important. Subclause 5 discusses about death sentence. Now, if there is a judgment on death sentence, then these words should be used. What is that? He be hanged by the neck till he is dead. These words should be the part of that particular judgment, which is what discussed in section 354 subclause 5. Now there is one case law that you can refer, that is Mohammed Chaman versus State of Delhi, where Supreme Court has explained the standards and norms for restricting imposition of death sentence. Now death sentence should not given until and unless it is very, very necessary. That is what discussed by the Supreme Court, which can be a reference point for you. And then comes the subclause 6, where there are 5 sections are mentioned. I have brought all the details of these 5 sections also for making your reference easy. Section 117, which discusses about order to give security. 138 actually discusses about procedure where he appears to show cause. Then 125 deals about order for maintenance of wives, children and parents. 145 deals with procedure where dispute concerning land or water is likely to cause breach of peace, or section 147 deals with dispute concerning right of use of land or water. In those cases, the orders of the points for determination should be very clearly mentioned. That is what given in subclause 6. I hope you have understood very clearly section 353 and 354. If you have understood them, then 50% of my job is done as far as judgment is concerned. I am going to cover the rest of 11 sections maybe in 1 or 2 more lectures. Thank you so much for subscribing my channel if you have already subscribed. If not, this is your time to subscribe my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.